Supreme Court, in the case of Sudershan Singh Wazir versus State NCT of Delhi, said that the orders dated 21st October 2023 and 4 November are quashed aside and set aside. It held that ex parte order of stay of the order of discharge should not have been passed by High Court. Consequences of such order are very drastic, as alluded. Hence, the ex parte order of stay was entirely illegal. Court said that the first impugned order had been passed ex parte while issuing notice by which the order of discharge was stayed. There was nothing placed on record to show that till the second impugned order was passed at any time, High Court had given opportunity to appellant to be heard on the prayer for stay. Second impugned order runs into as many as 26 pages and involves 62 paragraphs, which in substance holds that as the order of discharge was no longer operative, the status of the appellant as an accused had been restored and therefore he shall be forthwith taken into custody. Order staying the order of discharge is a very drastic order which has the effect of curtailing or taking away liberty granted to accused by discharge order. As a result, the order staying order of discharge ceases to operate and the sessions court can proceed to frame charges against accused and try him further. Order staying order of discharge by way of interim relief cannot be said to be in aid of final relief. It is only in rare and exceptional cases where order of discharge is expressly perverse that the revisional courts can take extreme step of saying that order. However, such an order should be passed only after giving an opportunity of being heard to the accused. Moreover, while granting the stay, court must mold the relief so a trial does not proceed against discharge accused. If trial against a discharge accused proceeds, even before revision application against order of discharge is decided, final outcome of revision will become fait accompli. Order of discharge stands on a higher pedestal than the order granting bail. By grant of bail, status of accused does not cease to be that of accused, but when order of discharge is passed, he ceases to be an accused. Power of the court to stay the order granting bail can be exercised only in rare and exceptional cases. As a discharged accused stands on a higher pedestal than accused released on bail, law laid down in the case of Parvinder Singh Khurana will apply more strictly and rigorously while dealing with application for grant of stay of order of discharge. In view of Section 411 of CRPC, Revisional Court can exercise power under Section 390 in a given case. Court, before the accused is brought, may commit him to prison pending disposal of the appeal or admit him to bail. Once an appeal against acquittal is admitted, status of person acquitted as an accused can be said to be restored. That is what is held in case of State of Uttar Pradesh versus Pusu. The object of Section 390 of CRPC is that ultimately the order of acquittal is converted into order of conviction. Accused must be available for undergoing sentence. Second object of section 390 is that when an appeal against acquittal is finally heard, accused's presence at hearing can be secured. Therefore, there is a power vested in High Court to arrest a acquitted accused and bring him before it or the trial court. Object is that the accused remains under jurisdiction of the court dealing with appeal against acquittal. It is well settled that order of acquittal further strengthens presumption of innocence of accused. Therefore, as normal rule, where an order under section 390 of CRPC is passed, accused must be admitted to bail rather than committing him to prison. It is well settled in jurisprudence that bail is a rule and jail is exception. This rule must be applied while exercising power under 390 of CRPC as the position of the acquitted accused is on higher pedestal than an accused facing trial. When an accused faces trial, he is presumed to be innocent until he is proven guilty. In the case of an acquitted accused, the presumption of innocence is further strengthened because of order of acquittal. Only in extreme and rare cases, by way of exception, can an order committing an acquitted accused to prison to be passed under Section 390. While exercising powers under Section 390 of CRPC, normal rule is that acquitted accused should not be committed to custody and direction should be issued to him to admit him to bail. This normal rule should apply all the more to cases where challenge is to the order of discharge, as the order of discharge is on higher pedestal than order of acquittal. Passing an order under Section 390 directing the discharge accused to admit to bail is sufficient to procure presence of discharge accused at the time of hearing of the revision application and for undergoing trial if the order of discharge is set aside.